Now I welcome you to chapter 3. Now this chapter 3 relates to the conduct of business, powers of authority and offences under the Financial Advisors Act and the Financial Advisors Regulations. Right? Here we are looking at some of the important notices. Now, looking at paragraph 2, now this is with regard to the general conduct of business, right? So generally, if you look at paragraph 2, there is this obligation of the principals, right? That is the word principals, all right, rather than financial advisor corporations or exam financial advisors, right? Of course, bear in mind that some of these notices apply to the licensed financial advisors and some of them apply to the exempt financial advisors, all right? But generally, I just use the word principals, okay? Now, there's an obligation of the principals to disclose product information to clients. Now, this is an important section that you must know, all right? This is section 25. Bear in mind section 25, right? This is one of the key provisions under the Act. One of the key provisions under the Financial Advisors Act. And this particular section has been read together with 23(4) and section 37 of the Act. Alright? So it provides that the financial advisor, the licensed financial advisor in this case, shall disclose to every client and every prospective client. So when we talk about client, we are talking about prospective client as well as existing client. Alright, so a prospective client is a client. Now, all material information relating to any designated investment products that a financial advisor recommends to such a person. Now, you know what are the designated investment products under the FAA. We have done that, right? And that's earlier in the earlier chapter where the designated investment products are set up. Right? These include life insurance, include investment-linked life policies, but excluding reinsurance. All right, you include collective investment schemes and capital market products. All right, you will refer to I think chapter 2, right, for the definition of the designated investment product. All right, so in that particular regard, so the obligation is there. It's a legal obligation. You have to disclose. The financial advisor has to disclose the terms and conditions of the designated investment product. All right, so the terms and conditions must be very clear. All right, if for life insurance, for example, all the product highlight sheets and all the other relevant information regarding that product must be disclosed. All right, the terms and conditions. Right, the benefits to be or likely to be derived from the designated investment product and the risks that may arise from the designated investment product. Now, this is particularly important when you are talking about investment-linked policies. You are talking about structured products, derivatives, and some of the more complex instruments. All right. So some of the retail investors out there may not be familiar with the benefits and the risks as well. All right. So see the premiums, the costs, the expenses, and whatever charges that may be imposed in terms of in respect of the designated investment product. Okay? So there may be fees up front. For example, unit trust, right? So any upfront fee, right? If you ask a client to switch a product, any switching fees, and so on. All right? So you need to be concerned about that. All right? And at D, for example, 2.1D, if the designated investment product is a unit in the collective investment scheme, the name of the manager. You must disclose the name of the manager. Who is the manager running this unit trust, this collective investment scheme, and the relationship between the licensed financial advisor and the manager. Okay? The manager is running the unit trust. The licensed financial advisor is maybe selling and giving financial advisory services on it. So what's the relationship? An example, life policy. I'm giving you an example there. The name of the licensed insurer under the life policy and the relationship between the licensed financial advisor and the insurer. Right? So the financial advisor is arranging life policies or giving financial advisory services on a life policy or investment link life policy. Right? But the insurer is underwriting the risk. So what is the relationship? Any conflict of interest? Right? Can the financial advisor uses the word independent, as I've spoken earlier in the course of this program? Right? So all these are obligations to be disclosed. And of course, such other information that the MAS may prescribe from time to time. So we are going to the details of some of these later on. This is the general under Division 1 or Part 3 of the FAA in terms of the conduct of business. So there's this obligation to disclose product information. Now, Section 25, as I said, is important, so take note of that. Now, let's look at paragraph 3. Now, paragraph 3 refers to the statements by licensed financial advisors. Now, as you may know, all right, so financial advisors will issue a lot of statements regarding their the financial advisors, the financial advice that they give, or the products, the designated products that they market and sell. So when you make statements, all right, so the statements must be clear, must be simple, they must not have any jargon as far as possible or technical terms that a retail investor may not understand. All right, so you must understand that in Singapore in particular, there are 4 languages, right? English, Chinese, Malay, and Tamil, right? Four official languages. And most of the statements, in fact, all the statements made by financial advisors are in English, right? And not every retail investor is literate or can understand English fully. So one has to be careful when you make statements to make sure that the statements are simple, okay? And as far as possible, as I've said before, with no jargon or technical terms. But more importantly, Section 26 reads, and I read to you, no licensed financial advisor shall, with intent to deceive, make a false or misleading statement. Right? So here they are is very specific under this, but the financial advisor is very specific in terms of Section 26. All right, among that would payable in respect of a proposed contract in respect of any investment product. Right? So your statement must be very clear. Right? It is not false, it is not misleading. That means don't understate, all right, the amount of money that would be payable in respect of a proposed contract, in respect of any designated investment product. Right? The effect of any provision of a contract or a proposed contract in respect of any investment product. Now, this is a bit difficult, right? The effect of any provision. So the terms and conditions of a contract are usually or are really drafted by the financial advisor corporation, the licensed financial advisor. Right? And they are usually in the standard form, the language, the words, all right? So what is the effect of each of these provisions? All right, so are they clear? Are they simple enough? Or are they misleading? Or are they drafted in the language or in words that have ambiguity? All right? So if those words are drafted, all right, deliberately, that means intend to deceive or false or misleading, then the financial advisor corporation or the principal will be in trouble, all right, in that regard. And I said before, under B, making a misleading statement include a reference to omitting to disclose any matter that is material to the statement. No, I cannot emphasize enough, the omission is a misstatement. Right? And of course, you look at paragraph C there, if you contravene Section 26, well, there's an imprisonment term of not exceeding 12 months. All right, there's a fine of not exceeding $50,000. Like I say before, generally the fine is 25,000. But in this regard, if a licensed financial advisor were to make a misleading statement or a false statement, or omit, all right, or omit to disclose any matter that's material omission, then the penalty is very severe. All right, so there's an imprisonment term of not exceeding 12 months, or a fine of 50,000, or both. So Section 26 is worth remembering, or for you to take note of, in terms of statements made by the licensed financial advisors. Right? Now then, under paragraph 4, you have got the recommendations by licensed financial advisors. All right, especially if we are talking about the general members of the public, the retail investors in particular. A financial advisor or a financial advisor representative is a professional, right? And you have the knowledge, all right? You want to market or sell certain tax-exempt products, and therefore, in that regard, all right, you need to make recommendation, all right, by a financial advisor to clients, all right, and especially if you are talking about retail client. You look at paragraph 4.1, the third line there, right? No licensed financial advisor shall make a recommendation with respect to any investment product. Now, this includes a life policy, which some people may think that is a very relative simple product, all right? To a person who may reasonably be expected to rely on the recommendation. Now, circle the word rely. So, it is a reliance test that the courts may use, or the court will use, all right? Whether your recommendation is suitable for the client, or whether you have a reasonable basis to make that recommendation to a client. Right? So that is the test. All right? So you must know your client. All right? If your client is an accredited investor or a qualified investor, well, you may be relieved of this responsibility or this obligation. Right? But if you are talking about a retail client who rely on your recommendation, right, to buy a certain product, all right, then you have this obligation to make sure that the product is suitable for the client. That's why you need to do your know your client analysis. You need to do the needs analysis. You need to understand the profile of a client, the investment objectives, the risk tolerance level of the client, whether the client has any dependents and things like that. All right. Right, that's section 27. It is another key section. I'll repeat, section 25, section 26, and section 27 are keys. Key sections in terms of the Financial Advisors Act that matters to the Financial Advisor Corporation as well as to the Financial Advisor representatives. Now, what is the meaning of a reasonable basis? A reasonable basis normally refers to what a reasonable person will think, knowing the facts and circumstances of the situation. All right, knowing the facts and circumstances of the case, what a reasonable person will think. All right, so this is sometimes in law what we call the reasonable person test. All right, so look at 4.2 closely. So you can set to have a reasonable basis, all right? If a customer complains that, no, the product is not suitable for me, you say, no, I have a reasonable basis to make this recommendation. So what will the court look at when, in its determination, whether your recommendation is reasonable or not? So the answer is set up at 4.2a. It has for the purpose of ascertaining that the recommendation is appropriate, meaning suitable, all right? Having regard to the information possessed by it. So you must get information from your client. And you must make sure to tell the client that whatever information that you give me as a financial advisor representative are true and correct and complete. All right? Because I will make the recommendation based on what information you are giving me. All right? So you have to make sure that you tell the client that. that whatever information you give me, that will be the basis I make my recommendation. If you hide any information from me, if you do not disclose certain information to me, then if I make the wrong recommendation, then it is your fault, all right, because you hide information from me. So therefore, the knowing the client bit is very, very important, all right? You must know and you must understand your client. Now here they give you very specific points, specific pointers, all right? So what is a reasonable basis? So the answer is concerning the investment objectives, all right, the financial situation and the particular needs of the person. So a financial advisor representative has to do a lot of work, all right, in terms of knowing the client, all right? What is the client's investment objectives, his financial status, his financial position now, and his particular needs, whether it's protection needs or accumulation needs or whatever needs a person may have. Right? Given such consideration to and conducted such investigation of. So sometimes what the client tell you may sound strange and so on. So you may have to do some investigation. Ask for documents, all right? Ask for whatever documents or do your necessary due diligence check, all right, to make sure that the information that you receive is correct. The subject matter of the recommendation as in reasonable in all the circumstances. So if there's a complaint made against a particular representative, right, and they say, oh, this product that this Mr. A representative recommended me is wrong, you know, and not suitable for me, then as far as the courts are concerned, the courts will say, hey, look, is it reasonable or not? Based on what has been said in that particular paragraph in terms of investment objectives, financial situation, and particular needs, right? So that is the key, all right, to protect a financial advisor representative and to protect the financial advisor corporation from being sued, all right? Therefore, you need to do your client's analysis very well, okay? At least even if you are being sued or the financial advisor representative or the financial advisor corporation is being sued, at least you got some basis to stand on and say, hey, look, we have done our due diligence, we have done our part, you know, we have make sure that the recommendation is appropriate, is suitable based on the information given to us and based on the investigation that make of the information that's been given to us. Okay. Now, Section 27(3) provides that where a licensed financial advisor in making a recommendation does not have a reasonable basis for making the recommendation, okay, the person in reliance against the reliance test on the recommendation does a particular act or refrains from doing a particular act. Right? It is reasonable, having regard to the recommendation and all the other relevant circumstances, for that person to do that act or refrain from doing that act, as the case may be, in reliance on the recommendation. And the person suffers loss or damage as a result of doing that act or refraining from doing the act, as the case may be. Then, without prejudice to any other remedy available to that person, the licensed financial advisor underlying this is liable to pay damages to that person in respect of that loss or damage. Now, this is pretty serious, all right? All right? So, therefore, 4.3 says very clearly, if you do not have a reasonable basis, all right, and the customer rely on your recommendation and do something, buy or don't buy, all right, and in the process, this particular customer suffer loss and damage, the financial advisor is liable to pay damages, all right, to that person in respect of that loss and damage. All right. So it's not just a return of the fees or the return of the premiums paid. All right. It is the loss and damage that the customer may have suffered. All right, relying on your recommendation. All right, and in this regard, the financial advisor, the licensed financial advisor, will have to pay damages. Now, this is an important point for the financial advisors, corporations to take note of. All right, and of course, the financial advisor representative, when you make the recommendation and it is a wrong recommendation and you do not have a reasonable basis, then you open up your principal, your licensed financial advisor, to pay damages. Right? Well, paying damages is one thing, which is of course painful and costly. But the other thing that the financial advisor should take note of is the reputational damage. Right? So that's why Section 27 is important. Okay. All right. So when you make a recommendation, when a licensed financial advisor make a recommendation to a client, you must take cognizance of this particular section. Okay. Now, paragraph 5 refers to a different matter. It refers to the receipt of client's money or property.